Good afternoon, everyone. Thank you so much for joining us to the first SIAC Korea webinar. My name is Michele Sonen, and I am the head of Northeast Asia at the Singapore International Arbitration Center, and I'll be your moderator this afternoon. Today, we're going to be discussing practical tips for managing documentary evidence in complex cases. But let me first start by introducing our all-star panel of experienced practitioners and in-house counsel. First up, we have Mr. John Bong. Maybe John, you can wave for everybody. Okay. John is a member of the SIAC Court of Arbitration, and he is the head of the International Arbitration and Litigation Practice Group at the Day, Kim & Lee law firm in Korea. Next, we have Mr. Chua Loon. Little wave, there we go. Kwan is the co-deputy head of the International Practice Group at Allen & Gledhill in Singapore. Next, we have Daryl, up there on the left. Daryl is a partner in the International Arbitration Practice Group at Shearman in Sterling, and he is also the head of the Singapore office. Daryl is also a member of our Young SIAC committee. Next, we have Andrew Kwan Hong. Andrew is the vice president at the Korea Shipbuilding and Offshore Engineering, which was formerly known as Hyundai Heavy Industries. And then finally, we have Mr. Matthew Skinner. Matt is a partner at Jones Day in Singapore, working in the global disputes practice. All five panelists today have extensive experience in complex international arbitration, and I, for one, am thrilled to be hearing their advice and insights on documentary evidence today. So without further ado, let's go ahead and get started. If I could start with John, you know, in popular media, oral advocacy and witness testimony are really portrayed as the cornerstone of a dispute lawyer's practice. But in the real world, in international arbitration, how important is documentary evidence?
Well, thank you, Michelle, and I want to thank the SIAC for inviting me to participate in this webinar with these distinguished colleagues. And I want to apologize to those who've logged on. My face is a lot bigger than usual because of COVID-19. That's what you get for eating without exercising for an extended period of time. I will not be offended if you message me to step back from the camera. So seriously, let me start with respect to general comments on documentary evidence and witness testimony. I believe that contemporaneous and probative documentary evidence is much more valuable and influential to a tribunal than good witness testimony. Of course, it depends on the case and your tribunal, but in my experience, probative documentary evidence can win you a case more frequently than good witness testimony. In fact, in my view, it's more often the case where a witness can harm or even lose a case for you rather than win one. Therefore, if you were to ask me to choose between probative documentary evidence and a star witness, I'll take the former pretty much every time. And good documentary evidence certainly makes your oral advocacy job much easier.
Yeah, that's a great point, that we'd rather have probative documentary evidence over witness testimony. It's just that much more valuable in a dispute. But when you're dealing with a case with a lot of documents, a lot of documentary evidence, especially in cross-border disputes, I think an issue that tends to arise but might be overlooked is translations of documents. Could you talk a bit about translations and how important that is, or if it's important at all?
Sure. The importance of translations of documents can never be overstated. As you all know, many international arbitration cases inherently involve significant number of documentary evidence in a language other than the language of the arbitration. Therefore, accurately translating that document into the language of the arbitration is critical, since the probative value or weight a tribunal gives to documentary evidence can turn on the translation. Because of this, we often have bilingual attorneys check the translation of key evidence after it has been translated by a translator.
So then would you say it's really important to ensure that for companies to bring on external counsel that can speak the language of the counterparty to make sure they can review translations?
I think it's always very important to have, I think, a counsel who's advocating your position to understand the language, particularly with respect to large, complex construction cases where there's so many documents involved. And so I think translation and having the ability to speak the language of the witness and relay that properly to the experts or other people involved in the arbitration is really essential to the case.
Do you think you need to also pick an arbitrator who speaks the language?
Well, I mean, that really is, you know, a case-by-case decision. If the case is very document-centric, and you're going to rely completely on documents that are in the original language, and that's essentially your entire case, then I think it's important to have somebody on the tribunal that can read that document in the original language, and if necessary, be able to you know, discuss that document with the other tribunal members. Obviously, if the other two tribunal members can't speak the language, they will probably give a lot of deference to the other arbitrator who can.
Yeah, those are great points. If we could turn next to Daryl, could you provide us with any practical illustration of a dispute involving extensive documentation and some of the challenges that have arisen?
Well, thank you, Michelle, and good afternoon, everyone. Well, the classic example that comes to mind are complex construction and project disputes, and unsurprisingly, they involve long-running projects requiring persistent interactions between owners, contractors, suppliers, and regulatory authorities. And in this context, a few challenges come to mind. First, the sheer volumes of documents and facts. Some of these disputes involve a massive project record over several years, and the challenge is to properly organize, review, and identify the right documents and evidence to support your case. I recall a construction arbitration we were involved in that ran for more than 6 years and involved literally millions of pages of submissions and evidence. The project continued to be built in parallel, so documents affecting the project continued to be produced on a daily basis, and we relied quite heavily on technology platforms to manage the record, both during the hearing and before that, because it was just impractical to rely on paper copies of the entire record. The challenges can be compounded in a cross-border context because evidence can be fragmented and dispersed. I mean, documents may be in the hands of employees and witnesses in different locations, in different languages. I think today there might be access issues due to COVID. Let's take a current example. Force majeure allegations have been made across different industry sectors and different projects. So if we assume a project in the Philippines, possibly with a Korean main contractor, a supply chain from China, possibly subcontractors from Japan, work has now been impeded at various points. There are differing impacts and restrictions in different jurisdictions. There are travel restrictions and lockdowns in different phases. And the team will have to navigate the web of national legislation in different languages. These might be updated weekly. There might be provincial regulations, executive orders. There might be certificates from the China Council of Promotion of International Trade. So one challenge is to start marshalling all of these documents and connecting the dots as early as possible. I guess one other challenge is that certain construction disputes turn on very technical and very esoteric issues. There could be disputes about different engineering disciplines involving the submission of statistical models and other complex simulations. I recall a case where both parties presented experts on dynamic stimulation. It's the use of a computer program to model the behavior of a complex system involving thousands of variables. So that presented its own logistical challenges.
Right.
And I guess one final challenge is document preservation and organization. I mean, some of the disputes involve events that happened many years ago. The documents may not be easily found, especially if the custodians have left the company. And it depends on companies having a reliable document preservation system. Some companies don't have that. So trying to recreate the chronology and the relevant facts can be challenging. Right. And that can be compounded by data privacy laws, which limits your ability to produce communications which include data.
Yeah, those are some great points. I think we'll discuss how best to overcome some of these challenges a little bit later in the webinar. But yeah, it's important to point some of those out. I can't imagine dealing with millions of documents. John, I know you've also worked on some very complex construction cases involving Korean companies. Could you tell us about your experiences there?
Sure. I had a similar experience with like Daryl, where we had a big complex construction case with over 25 claims and counterclaims. And when you have over 25 claims, they're essentially 25 different causes of action. So you can, and which means that the facts and circumstances of each claim are different. And so you can imagine how many documents that you can have. And we also had more documents than you can imagine. And therefore, we were contemplating what we're going to do. What should we do at the hearing? We obviously can't print all those documents, at least, and have 3 or 4 copies for each party and witness. So what we decided was to have only one full set of hard copies. But since a particular document could be 100 or several thousand pages long, we only printed the first 30 pages of each document. So we had one full set of hard copies at the hearing room. We almost didn't have enough shelf space for just that one set. Yeah. And we used PDF versions, electronic versions of the documents during the hearing via a service provider. And I think it really helped to have one hard copy, because sometimes when you're looking at the screen, certain documents on a PDF are not legible. And therefore, we were able to utilize some of the hard copies during the hearing when we needed to. Now, yeah,
sometimes it's easier to find pages when you've got it in hard copy instead of a PDF.
And now on the complete opposite of the spectrum, there are few documents, very few documents in some post-M&A disputes. I've been involved in a lot of post-M&A disputes, and some representing the seller side. And normally the seller side either gets rid of or usually leaves all the documents with the purchaser after the closing. So you're essentially documentless, a complete opposite of in a construction dispute. Right. And so I'll touch on that a little bit when we discuss the differences between civil law and common law perspectives of document production.
Okay, thanks for that. And Daryl, real quick, any thoughts on how the current COVID pandemic may affect management of documentary evidence?
Well, I think the pandemic is likely to accelerate some of the global disruptive megatrends that were already picking up pace, one of which is the increasing reliance on technology, on digitization, automation. And with the extensive lockdowns and increased virtual interactions across businesses today, I think there is heightened sensitivity to the importance of data preservation and organization, virtual administration of processes. I mean, some of our cases, preparation and presentation of it has been impeded due to access issues to project sites, witnesses, and documents. And I think as companies emerge from the immediate aftermath of the initial shocks, they will start to audit and rethink their work processes, including how they create, how they store documents, how they access documents and secure documents remotely. And this should have an impact on the management of evidence. I mean, consider, for example, the increased use today of recorded virtual meetings, of messaging platforms, digital authentication of documents, And as we all transition to virtual hearings, there will be a difference in the way we navigate and present documents to tribunals. There will be more reliance on technology-assisted platforms, for example, that allow parties to pull up documents on shared screens, to annotate documents remotely. In short, I think we can expect technology to play a bigger role in the management and presentation of evidence. So yes, this is a very topical issue as we all prepare to navigate the post-COVID world.
Absolutely. We're forcing the industry to go more technological. Thanks for those comments, Daryl and John. If we could move on a bit and talk about the creation of documentary evidence and what companies can do to ensure that they're properly documenting their projects and their transactions. If I could turn to Matt, do you think you could speak a bit about the role that legal teams play in ensuring sufficient documentation and organization of documents?
Yeah, absolutely. Good afternoon, everyone, and thank you again, Michele. It's great to be involved. I think that the reality of it is approaching this as external counsel is that we are always in the position where we're trying to gather the documents together and really look at certain key events and work out, you know, what has happened, saying, you know, we wish that they could be more organized from a project perspective. And when we talk a little bit more about when looking at documents for the purposes of arbitration and organizing them and saving costs, the reality of it is that the more organized they are at the beginning, then the more efficient that process ultimately becomes. But I think also, I mean, whilst that might be our preference as lawyers in terms of preparing for a case, and Andrew can probably talk about this a little bit more. You know, the fact is that the business is organized in a particular way and projects are organized in a particular way, and they have been successful. So persuading them to change that and the way that they organize documents ultimately it can be very, very difficult. But what I thought I would do is just share, I suppose, a recent example of a case in respect that we're working on at the moment. And the client, it's a large construction project taking place here in Singapore. And the client has a very sophisticated project management system. And so when a particular incident arises, let's say, for example, it's an incident that may give rise to an extension of time, then they have this project management software which really enables them to upload the correspondence at that particular moment in time, feed in the considerations, they might be feeding in legal advice as well. And ultimately that means that when you get to the point potentially of a dispute, was this a proper variation or whatever, are there potential waiver arguments that are available? You've got this, at least the start of a dedicated timeline or a package of documents that you can look to. And that obviously helps, because the situation that we normally end up in is that we're trying to find all of that relevant material. The other point that I would add about managing documents during the course of the project is that, and Daryl touched upon this, is that there are often issues with custody. I mean, a lot of companies operate what we call project drives, and that's where everybody who's working on the matter is obliged to say copy emails to the project drives or to the project folder. Now that doesn't always happen, but that is obviously developed, establishes a repository of material that can be used when the arbitration ultimately arises. Sorry, shouldn't be so pessimistic. But so that is obviously very valuable as well. But I think one of the big necessarily permanent, they're sometimes contractors, they're given a laptop, they're working on site, and they may not have good internet access. So what you tend to find is a lot of documents and material get saved to their personal laptops. And when they leave the company, those laptops are potentially erased, so you lose a lot of that data and material. So again, I think that the role of the legal teams, and again, we need to be realistic that the legal teams only really tend to get involved when issues become particularly contentious. So in some respects, the role of the legal teams is to sort of set the project up at the beginning to make sure that there are these protocols in place for recording information about key events, particularly when, I mean, there has been recent case law which obviously suggests that clauses in English law contracts that provide, for example, for variations to be recorded in writing, that they will be strictly upheld and strictly observed. So it's you know, that information needs to be recorded and be made properly available. And also, as I said, going back to making sure, for example, that there are proper protocols in place to make sure that when people leave, their laptops are retrieved and that information is downloaded and secured for any potential dispute that may come in down the track.
Sure. Andrew, as our senior in-house counsel representative here, is this consistent with your practice at Korea Shipbuilding Offshore Engineering? What can you add? What tips can you add for other companies who are going to be engaged in arbitration?
Yeah, sure. I cannot speak for other companies, but I can share some policies and some practices that we do here at KSOE. Matt has touched upon what I'm going to say. You know, the point is, you know, as a lawyer, we want to have an ideal, you know, set of documents, complete document, well organized, you know, without mistake. You know, anything that we want to use as a case, you know, we have in front of us, you know, something like that. But in reality, the documentation that's created during the project, that's for the purposes of running the project, not in anticipation of a dispute.
Right.
And creating a set of documentation and have a organization system is a cost to the company. So how much of the legal environment we have in a project is a quite delicate cost-benefit analysis for a company. And from a company's perspective, cost always look greater than the benefit, which will come as a remote possibility in a case of a dispute. So it's not very clear computation, but the presumption is against have a robust documentation system for the purpose of the litigation or arbitration. That's the kind of default setting. We have to realize that reality and figure out, you know, what we can do with what we have.
Yeah, that makes sense. I think sometimes the external lawyers want to have the best documentation, but the, you know, in-house really does need to do the cost-benefit analysis at the time. Keelan, you know, or before we turn to Keelan, Matt, you know you mentioned to me something called a roles and responsibility matrix. Could you talk a bit about how that works and whether, you know, how companies could use that during projects?
Yeah, sure. So, I mean, the purpose of the roles and responsibilities matrix, it really helps when the arbitration ultimately arises, because, I mean, one of the things that we want to identify, who are the key custodians, might have the relevant documents, but also who are the people who might ultimately be called as witness project, particularly if it's a long-running project. The fact is the project team does change. So it's also important that roles and responsibilities matrix is really kept up to date, because it really does assist us further down the track. I mean, often these types of matrices are required by the owners. You know, they know and need to know who is working on the project in a particular time and who is responsible for certain things. But if you look at the evolution of that plan over time, the evolution of that matrix over time, then that in itself tells you a story about how the project is being managed, how it's being excessive amount of turnover or frequent turnover at some of the lead engineering positions, then that may raise questions in itself that you'd want to sort of properly understand, because that can lead to significant questions, I suppose, because continuity is something that all owners really tend to value. And again, if you're looking from an efficiency perspective, having that continuity is certainly very helpful.
Okay, yeah, that makes sense. Maybe we can turn now to sort of the role of external counsel in all this, and if we could start with Loon and get some of your insights on the role of external counsel during projects before a dispute arises.
Yeah, thank you, Michele. I think I completely agree with Andrew that the reality of the real world is that the documents, I'm talking about the document creation process. The documents are being created by people in the project who don't necessarily, in fact, most of the time, do not view the situation in the context of a potential dispute. They tend to look at it on a cost-benefit basis. The technical people would be drafting the documents on the basis of wanting to complete the project. And I think that usually where we will have problems with the documentary evidence. And I think it is precisely because of this, it is important for the legal counsel to play a very important role to ensure that the documents that have been created during the course of the project are essentially documents that would have a view on a potential dispute happening, even though it may be at a very early stage. And what do I mean by this? And I think the mindset, especially when you're dealing with a very large project, it is important to have a case building mindset right from the outset, in the sense that when documents are being created, you've got to ensure that the position that the company takes is consistent with the contractual position of the parties, and it's legally correct in that sense. So I think one of the most important role legal counsel, the internal legal counsel, can play during the course of the project is put in place some form of system whereby these documents, where the project people are taking any legal position, they would go through the legal team, the internal legal team, and have them vetted to ensure that at the very least that the position taken is contractually correct. And I think and my experience is that in recent years, we are beginning to see a trend whereby there are a lot of very sophisticated legal counsel who are very mindful of this issue, and they have been proactively ensuring that the documents created during the course of the projects, even way before a dispute arises, are properly vetted to ensure that they are contractually correct in that sense.
Yeah, sure. Matt, as very experienced external counsel dealing with companies engaged in various projects and disputes, what could you add on the advice front what kind of advice could you provide during a project before a dispute arises?
I think that's an interesting question, and I agree with what Loon said. That I mean, we do see obviously clients being much more sophisticated and selective, and for the whistles, in terms of how they use external counsel during the course of a project. I mean, one thing that crosses my mind is that, I mean, it may be worth engaging or interacting with external counsel in some circumstances where you're looking to preserve privilege, for example. Mm-hmm. I mean, that obviously provides some value, particularly when you're dealing with an international project that perhaps involves a client who is based in a country or who is doing a project in a country, doesn't really have the formal recognition of privilege as we do in say England or Singapore. So it's a place where external counsel can potentially be involved. In terms of organizing the documents, I mean, if the internal legal team is unable to persuade the business or engage with the business in how they should organize their documents, then I think the chances of external counsel persuading them, I think, are even more removed. So I don't think we would have much of a voice on that, and rightly so.
Yeah. Yeah, fair enough. All right, well then let's move to once a dispute arises, where I would think that external counsel does have much more influence. What, you know, Andrew, if we could start with you, how does the role of in-house counsel change once a dispute actually arises?
Interesting question. Once the dispute arises, the first thing that the in-house does is to determine the seriousness of the claim or the dispute and how impending a formal proceeding is, you know, like the arbitration or litigation. And based on those determination, we decide whether to handle that matter internally or bring in an extra hand from the outside. That's the first step. When it comes to the the handling of the documents, we will do the initial interviews and figure out where the starting documents lies in, and decide what would be the key documents. So we have the initial idea of what those key documents would be. And if the claim is relatively small and we just handle internally, we just deal with those key documents and get it over with. But if the claim gets bigger and if we need to collect bigger pool of documents from various sources, then another first thing that we do is to do the source mapping. We understand where the documents are stored. There can be various sources, company server, for one thing, a hard disk, and then some people use their laptops, not just one laptop, two laptops, multiple laptops at the project site, and when they come back to headquarters and things like that. So there are various sources spread out. So we need to figure out and identify where those sources exactly locate. So that's what I call the source mapping. The external counsel can do that, but we are close to the company and we are close to people in the IT department. So I think it is more efficient for in-house counsel to do that. And this is our company in any event. We need to understand our own system. And once we do the source mapping, we also need to do figure out who will be the potential likely witnesses. When we talk about collection, what that entails is the source of the data, which I just spoke about, and the people from whom we collect the data from, and the duration of the data that we collect. So, for example, a person A works in a project for 5 years. We do not need to collect all 5 years of documents that person created. So we need to pinpoint to the extent possible what's the relevant duration of the related to the dispute. We also need to identify the type of the files that we need to collect. If we are talking about email, we do not need to collect all the design, the drawings with big file capacity. So those things are the major factors that we need to consider and identify. And if we bring the external counsel, we certainly discuss these matters with the external counsel to make the flow more smooth. In eventuality, the data would flow to the external counsel for their review. So we do not want to do something unnecessary or duplicate when the external counsel comes in and do their own, the data analysis.
Right. Did you want to add something? Oh, okay.
Oh, well, that's the collection parts. And I just wanted to add one aspect about the processing. Once you collect the data, then what you need to do is to process the data. For example, in a very big construction project, the volume of files amounts to millions of documents and terabytes. It's a huge volume of documents, and just people going through each document manually is impossibility. In that case, you need to bring in a extra vendor, IT vendor, to do the processing of the documents. One of the key features of those the IT vendor bring is the deduplication. What that does is, you understand, in these days, many people are copied in one email, and if we collect from, let's say, 10 people, then 10 people has in the same version of email 10 times. So if the manual reviewer goes through those duplicates, it's waste of time. So deduplication, get rid of all the duplicate copies and leaves just one copy. And in order for us to do the deduplication, what's important is to have the priority of the people against to whom the deduplication will be conducted. So let's say A and B have same version of copy. Then what we need to decide is whose version survives over whose. Is it going to be A's document, or is it going to be B's documents that survive?
Right.
So that means we need to determine who will be the key witness over different potential witness. We need to have the priority of the witnesses and documents, and that's also tied to the kind of the case theory. So it's not just a very technical process, it's a process of understanding the case, having the roadmap for the case in place, and reflect that in the deduplication or the processing process. So it's all tied up.
Okay, I think that's a nice segue into talking also about, how do we keep document review, a collection of documents, and also document production cost efficient when you're looking at so many documents, and like you brought up, there's a lot of duplication. So perhaps I can turn to Daryl to talk about what we can do, what companies can do to make document review and document production more cost efficient.
Sure. Well, Andrew touched on some of this. I think given the volume of documents involved, it's important to have a proper plan and structure and process in place. In terms of tools, there are a wide range of tools available today that can help improve efficiency, from document review platforms, software, artificial intelligence assisted applications. There's specialized vendors as well, as Andrew alluded to. For document review platforms, what they allow you to do is to upload large volumes of data. You can review them, you can quote them, you can host them in a single location. And as Andrew mentioned, the system helps you to streamline the volume of documents through processes like deduplication. There are processes called email threading, concept clustering, and key term identification. There are many different functions available now to help you streamline and make sense of the document universe. There are also software applications that help you to visualize data in a more efficient way. They can help you identify trends in data types. They help the internal and external counsel team collaborate on shared workspaces, on fairly user-friendly dashboards. And you also have specialized vendors who assist in case presentation, whether it's the creation of hyperlinked chronologies, hyperlinked submissions, roadmaps. Some of you may be wondering what some of these examples are. On the IBA website, there is a helpful list of some of these vendors and tools. They include tools like Opus Magnum, like Transcend, Case Map. There is a long list, and it requires some investment, but given the volume of documents, some of these tools will greatly improve efficiency and meet the needs of your case.
Okay. Matt, could you give us some thoughts on document management software? I know that's something you have some experience working with.
Yes, I do. I'm happy to share. I'll share perhaps I'll share an example of a recent case that we're working on. So, and I think it's interesting because what we've seen, particularly when we look at the courts in Australia, is that they seem to be very willing to adopt, or they've set up these protocols for what they call predictive coding. So, I mean, back in the good old days, or maybe they weren't so good, it was the lawyers who had to go through documents and identify what was relevant. Now what you can do is you can train the computer. So the computer will search the documents, and you can train the computer to identify what is relevant. And as I said, there's a number of protocols in place in Australia which really govern how that is to be administered by the courts. We're working on a case at the moment down there, which is a huge mega gas project. Our client had about 7 million documents that were potentially relevant. And given the magnitude of that task, which would obviously take years for lawyers to go through themselves, they agreed to invest in predictive coding. Now, that does require an investment. And, whereas traditionally, document discovery and production was really the preserve of junior lawyers stuck in some windowless room. And the team, including partners. So we had a team of about 4 or 5 lawyers who worked on, including 2 partners, who worked on it continuously for 6 weeks and ultimately trained the computer so that it could go through all of these documents and identify and spit out a team of lawyers doing it. And I think the feedback really is that it has been effective. And the interesting thing about that particular case is that normally the computer would identify what's relevant, and then you would have lawyers go through and essentially do a second-line review. But because the volume of documents was so large, even at the end of the computer having understood what was relevant, the parties agreed to a blind disclosure. So what that meant was that there was no second line review by the lawyers. So it was all ultimately done by the computers.
Wow.
So yeah, it's pretty interesting. And that for these large projects with large numbers of documents, I think that's going to become more important.
Yeah, so I imagine the software is expensive, but it's worth the cost because you're saving significantly on lawyers' hourly rates and so forth. Okay. All right, let's see. Let's move on to another topic. One important thing that companies are often thinking about is how to make sure their data is confidential, especially when you have companies that are collecting private data or when you have companies dealing with IP. Could you share your thoughts on keeping, keeping personal data confidential? And maybe Matt could talk a little bit about that. And then I know John has some comments. He's had a unique experience with in-camera review. And for the audience, if you don't mind, while they talk about that, I'm going to close my blinds because I know that I'm in the light and in the shadow. So Matt and John, please go ahead and talk about confidential documents.
Yeah, well, I think the first point that I would make is that when we all obviously practice in the arbitration space, and there is, I think, a presumption by all of us that arbitrations are confidential and that material shared during the course of an arbitration will remain confidential as between the parties. Now, the fact is that that is not necessarily true, and there are a number of exceptions to the confidentiality obligations in arbitrations, including, for example, if you need to use that information to further your legal rights. And that is obviously a very broad test. and there have been, at least we've been involved in instances where there are questions as to whether the documents can be used for ulterior purposes. So I think it's important to bear in mind that arbitrations are not as confidential as they may seem. What I really wanted to touch on here was the increasing encroachment of personal data and privacy laws. They are relevant in the arbitration context, notwithstanding that it may be confidential, because normally how those laws operate is that they completely prevent the disclosure of personal information to third parties, and they are mandatory laws and they have to be observed. So I think it's very, very important data and privacy laws of the country where the server is stored. But ultimately, if you do run across this, there is no real cheap or efficient way of dealing with it, particularly if the other party, or if you need to insist upon disclosure, or if you need to rely upon that data to ultimately prove your case. It may be possible to get personal exemptions or personal waivers, and some of those will obviously be contained within employment contracts and that sort of thing. But you often end up having to redact a lot of the personal information. And often, particularly if it's hard copies, that has to be done by hand, and that can ultimately be very expensive and lead to a significant increase in the cost of the arbitration. So it's really something to be aware of, and I think flag in advance to the client that this is something that we need to keep an eye on, and try and sort of identify it early in the process to limit surprises down the track. Yeah,
sure. And then John, you know, you've had an interesting or unique experience with in-camera review. I think that in-camera review is not used all that often, but maybe it's something companies can think about, and companies and practitioners can think about using when they have confidential documents.
Thanks, Michelle. Matt, right before I begin, Matt, you talked about the good old days or the not so good old days when you had to review documents. I remember being in windowless room with 30 boxes with a piece of paper that said relevant, hot, or not. And so they were definitely not the good old days before these great review and different technology software have come to us as disputes lawyers. But so I want to share briefly a unique and successful experience of in-camera review by a separate adjudicator appointed by the parties and accepted by the tribunal. When you're in a case where your client does not want to disclose many confidential and sensitive documents that are responsive to document requests, and there are many disputed issues related to either the non-production of those documents or how those documents have been redacted, and the client does not want your tribunal to review these documents in camera because it may negatively affect the impression of the tribunal before the hearing and the rendering of the award, then you may want to consider appointing a separate adjudicator to address the document disclosure issues or disputes. In short, you essentially exchange submissions, include the reference schedule and the privilege logs, and of course submit the unredacted version of the documents in dispute, and potentially have a quick conference call with oral argument. And then the adjudicator makes the decision. I've had this done a few times, and you know, I think we've received fair and reasoned decisions. And given the unique process, I think it helped that the adjudicator could not be influenced by the entire arbitration record, including a lot of the disputes that happen and the accusations that go along with those procedural and other disputes when making the decision. And so, but most importantly, the client was satisfied. So if you're ever in that position, you may want to think about that. But of course, there are certain hurdles that you need to overcome to undertake this process. That's plenty of time, accommodating opposing counsel, and a understanding tribunal, and possibly a busy tribunal may also help as well.
Okay, thanks for that insight. I think that's something maybe we'll have some practitioners trying in the near future. All right, last topic for today's session before we move on to some Q&A. You know, Korea is a civil law jurisdiction, and you know, for companies based in civil law jurisdictions like Korea, the expectations for document production might be very different from the expectations of companies that are based in common law jurisdictions. So if I could start with John again. You know, as a common law trained lawyer practicing in a civil law jurisdiction, can you shed some light on what Korean companies can expect, or companies in other civil law jurisdictions can expect when members of their tribunal are common law trained?
I think I'll let Andrew talk about more on the company perspective, but the topic of really comparing the common law and civil law approaches to document production, or other features for that matter in arbitration, very interesting and could be discussed for hours. The one point that I wanted to make is that, in my view, there is generally less distinction these days between the two approaches because of the widespread use of red fern schedules and the application of the IBA rules on the taking of evidence in arbitration. However, of course, before this widespread use of the red fern schedules and the IBA rules, we considered the common law approach to document production much more often, and it impacted our selection of arbitral tribunals, actually. Everyone will recall the Asia financial crisis that occurred back in the end of 1997. And because of the crisis for about 5 to 7 years, more than half of the arbitration cases that we had were post-M&A disputes. And if you recall, the Korean government had essentially forced the big companies to sell off their 9 core businesses. And that meant that there were a lot of deals, and for the benefit of us dispute lawyers, then a lot of disputes after those deals. And given that we were on the side of the seller, as I mentioned previously, we essentially started with no documents and no witnesses. And so we were thinking internally, maybe we need somebody with more of a common law background so that we can find an arbitrator who would be more understanding and supportive of the overall document disclosure process, including the exchange of documents before the substantial pleadings, which doesn't really occur these days. Needless to say, some tries were more successful than others.
Great. You know, Andrew, as John alluded to, you know, having worked with the company, is your experience any different? Do you feel that, you know, there is a big difference between common law tribunals and civil law tribunals?
Well, I agree to John that there is a trend that show quite similarity in handling the document these days. But one thing that I should caution the audience would be that in certain rare occasions, there can be very typical I should be very, very careful how I frame this. Very old generation, the ex-judges from English tradition, they can be quite prone to rule on extensive documents. In recent years, in one arbitration, we were ordered to follow the English standard disclosure process, which requires us to produce all the relevant documents, not just relevant to our case, but relevant to the other case, to the other side case. All the adversarial, all the evidence that negative to our case as well. So in that extreme case, it came to quite a surprise to us in that arbitration. The tribunal was whole, common law background, old generation ex-judge QCs. So the point that I'm wanting to make here is not to say whether that was right thing or wrong thing to do. Just trying to say is that when you form an arbitrary tribunal, the disclosure tendency is one factor that you should consider. And not just thinking from the technical aspect of the document, you should see it from a strategic perspective as well. Do we want a wide disclosure in this case, or we want narrow disclosure? That type of thing.
Sure. Thanks, Andrew. Loon, coming from the other side, common law, practicing in a common law jurisdiction. What can companies in civil law jurisdictions expect from companies in common law jurisdictions when those companies are making their disclosure requests?
I think I completely agree with John that in the development of the international arbitration these days, over the last few years, the difference between the civil law arbitrators and the common law arbitrators, it's narrowing. It's to be less and less different in a sense, and this is mainly because of the IBA rules on taking of evidence, where there's a requirement of materiality to the documents being passed off, and not merely relevance. So I think the IBA rules manages to merge these two traditions fairly successfully. But having said that, I also completely am sympathetic and agree with Andrew as well, because there remains this tendency of certain civil law arbitrators, based on my experience, it's more difficult to get disclosures from civil law arbitrators. That's the experience that we have. But I think that the tendency is slight, and it's getting less and less these days. I think there is a merger of the principles of international arbitration. But Andrew is right. When we select arbitrators, this is an issue at the forefront of our consideration. It's not the only one, obviously, but it's definitely a factor when we decide on the arbitrators that in a particular case.
Good.
Michele,
Okay.
when I mentioned the post-M&A disputes back 15 years ago, and the selection of arbitral tribunal, I think that was a huge factor for us when we were selected tribunals back then, because without documents, we were not able to defend or pursue defenses or cases.
Right. Yeah, so I think the consensus is it really does depend on the strategy for your case, but glad to see there is sort of a narrowing, much more internationalization of arbitration these days. Well, we've got, about 10 minutes left, so let's turn now to some Q&As from our viewers. If I could start with Daryl, here's a question that we received. In the practice of international arbitration, how do you prove that the evidence or the documents that are submitted by parties are authentic? And then the second part of the question is, how does the arbitration tribunal know that the parties who are submitting the documents are being honest or forthcoming?
Well, I guess challenges to authenticity of documents have to be taken by counsel and substantiated like any other allegation. So for example, if there is an allegation of forgery, one would expect a party to substantiate that allegation, and that may be debated through objective evidence or potentially expert input. I mean, we have seen cases where handwriting samples have been analyzed to see if they were authored by the same person. There are also other parameters that you can look at, for example, metadata, which forensic experts can look into. So I don't think it's very different from any other allegation where the tribunal will have to assess on the basis of the evidence put forward whether the document is indeed authentic and what the implications are of that.
If I could just add, Michele, I mean,
yeah, of course.
Unlike the United States, where you need to authenticate documents and you have lawyers essentially submit affidavits to authenticate, or you have a witness on a stand that authenticates the document. I think in international arbitration, the parties essentially police each other and see if there's any documents that, if there's any cause for a doubt, then you raise that in arbitration and you seek relief through the tribunal, or you raise obviously first the issue to the other party and try to resolve it. But there is really no formal way. Obviously, Daryl, when you're in a, as he said, when you're in a case where you need to actually authenticate a document that's absolutely probative to an issue, and you need to look at the handwriting samples, that happens. But I think generally speaking, it's the parties that police the authentication of documents.
Yeah, sure. Okay, let's see. We've got another question here, and this one is related to COVID. Maybe Matt, you could take this one, but anyone, please feel free to chime in. How is document production being affected given the office closures and travel restrictions caused by the COVID-19 outbreak?
Look, that is a very good question. I mean, we have a couple of live says this is that where the documents have been collated and uploaded, it's not really a problem because, I mean, all of these platforms are remote platforms. And the reality of it is that as soon as they're set up and that they're on the system, it doesn't really matter where you are. So you can review, you can be in Singapore, you can be in your home, you can be in Australia, the US, wherever it might be, and you can get access to that material and you can review it, you can identify what's relevant. And then in terms of actually putting that material into a form that can be shared with the other side, I mean, that is obviously done by whoever's hosting the database. And obviously some of them do have some restrictions and limitations with resources, but again, I mean, whether you internet link or data link, or whether you're burning it onto a hard drive and producing it to them, or getting it couriered to them, it's not too much of a problem from that perspective. Now, when we're talking about matters that Andrew was referring to, which is obviously identifying all the sources of the relevant documents, where they are, and then collating them all in one place so that they can be put on the database, then that's a bit more problematic. But in my experience, I mean, I think at this stage, certainly parties and tribunals are very sensitive to the problems that are being created by COVID-19. I think we'll see whether people continue to be as patient as we start to come out of lockdown. But at the moment, I haven't noticed any significant problems.
Okay, well, that's promising. I know we've got problems with witness testimony, but glad to know that documentary evidence isn't causing too much headache for parties in light of the COVID-19 situation. All right, we've got another one. Specifically for, hang on. Okay, before we move on there, somebody's got a question about the software, document organization software, and specifically, is there any available software for storing and organizing evidence in real time during the proceedings, I guess during an arbitration proceedings? Those of you that have experience using that kind of software, maybe you could just share which software you liked and what's been useful.
One example, Michele, is Opus Magnum. What that does is it allowed us to host the entire arbitral record on a platform, and everyone was using that platform from the tribunal to counsel, and it allowed us to work on shared workspaces. It allowed us to annotate documents privately and to demonstrate certain points to the tribunal. So that is one tool. Another one is Transcend. And as I mentioned, there is a list of these technology resources on the IBA website. So IBA, International Bar Association. I believe the website is titled something like Technology Resources for Arbitration or something to that effect. So if you Google that, it should come up.
Okay, that's helpful. Yeah, I think parties will be able to go there and check out some of that software. Okay, we've got a question directed at Andrew, and perhaps this will be our last question for the day. And the question is, do you recall whether your cases in which the standard disclosure was ordered, if those cases were LMAA arbitrations? And this person is asking because the default position in the LMAA rules is standard disclosure.
Yeah, actually, I was typing my answer on the screen. Now that you addressed the question to me, yes, it was an LMA case, and I entirely agree that it was an exception to the general trend. But at the same time, I would say that more common law educated arbitrators have shown in the cases that our company has involved in showed a tendency toward more extensive the disclosure compared to the civil law educated, trained background arbitrators.
Okay, that's great.
So the key thing is be very careful when you choose your tribunal, which means you have to be very careful in choosing your lawyers who help you choose the tribunal. So.
Absolutely, and very careful when you're choosing your institution as well.
I was about to say that, Michele.
All right, well, does anyone have any final comments before we wrap up here? No? All right, well, thank you so much to our panelists for sharing their insights with us. It was a really great session. And thank you so much to our viewers for tuning in. This session was recorded, so it will be available on the SIAC social media accounts should you want to rewatch it or send it over to your friends to take a look at. We will be continuing the SIAC International Arbitration webinar series with another webinar this Friday on CISG in international arbitration, so I hope you can join us for that. Until then, thank you so much for being here, and I hope everyone has a great evening.
Thank you.
Thank you.
Thank you.
Thank you.